usually stay away from American stuff, particularly because Americans draft really badly. They really just have this very old-fashioned way of writing, particularly about the law and legal contracts as well. A lot of passive voice, a lot of stuff that really we don't use anymore in modern Australian legal context. But I actually think this, even though it's a little bit hard to navigate, is probably one of the best definitions of offer I've seen. So an offer is the manifestation of willingness to enter into a bargain, enter into a contract, enter into an exchange, so made as to justify another person in understanding, let's turn that into English, made in a way so that another person would understand that his assent to that bargain, that their agreement or their acceptance of that contract, that offer, is asked for, that we're asking for their consent, and we'll conclude it. We'll create the contract. I think it's good, it brings all of the pieces in. I probably should sit there and rewrite it into plain English myself one day, but I think it's a useful way to think about an offer. And it is worth, with every offer, thinking about, do we have all of those things? Can I see that there is an intention that I'm bound if I accept this? Oh, wrong button. Okay, so let's start talking about some cases. We're finally in contract law. Let's talk about some cases. So this was one of the cases that you had to read, Gibson and Manchester City Council. How many of you have actually been to Manchester? A few? Any of you remember? It's all, so I hate to say, it's all us oldies. It's been to Manchester. Manchester was a happening place in the 80s when I was having my big adventure. This is actually what it looks like, a lot of it. These are Manchester council houses. Thing about Manchester, it's not a place where you ever look at anything during the day. You're only awake at night. That's the way it works. So back in the 1970s, the Manchester City Council had a policy that it was going to privatise the council homes. So effectively, for generations, homes like those ones were built and maintained by the council and local people rented them. And that's a very standard way of living in that part of the world. And they said, okay, what we're going to do is we're going to get these assets off our balance sheet. We're going to let the tenants buy these houses. We're going to finance the buying of the houses for them. So effectively what we're going to do is sell them to them and lend them the money to buy them, and they're going to grant us mortgages. So here, you're going to start thinking like lawyers here. Some of you will have homes that are mortgaged. Chances are the language that you have used is, I got a mortgage from the bank. And what you mean when you say that is, the bank loaned me some money and I had to sign some documents that mean that if I don't pay them back, they can sell my house and take it away from underneath me. Agreed? That's pretty much what we understand those words to mean. In fact, as a matter of law, the owner of the property gives a mortgage to the person or entity that lends them money. So what a mortgage is the giving of a security to another person. So granting a security right. So I tend to say in normal conversation, oh, yeah, the bank owns most of my house. Actually, the bank doesn't own any of my house. No, I'm a lawyer. Of course, I don't own anything. My husband, in fact, owns our house, and he has borrowed a large sum of money from the bank, and he has granted the bank a mortgage over our house, which I've then had to co-guarantee because I'm a lawyer. That's what we do. We take debt. We don't actually own assets. Just that's how it works. So, in fact, we give a mortgage. So again, when you were reading the case, some of the language in the letters about the mortgage might have been confusing because the underlying assumption that you have is the mortgage is something you get from the bank. I just wanted to point that out. I've already worked out we've got at least a couple of conveyancers in here who will be able to set us straight on those things. So Mr. Gibson being one of the tenants in a council house, wrote to the council or applied to the council to ask about buying his house. I won't actually, on the recording we've already gone to the letter, but you will see it's impossible to read on the screen here, but that's taken straight from your case extract. A letter came from Mr. H.R. Page, the City Treasurer, to Mr. Gibson, and basically set out the basis on which they would be or might be prepared to sell the house. Then, as is the way in local councils, actually not quite yet. So Gibson basically completed the application form. The form itself had the words application to buy a council house. He completed it all, signed it. He didn't put in the price. The relevance of that you should consider. And he sent it back on the 5th of March 1971, at which point it would be processed. Now, as is the way of local councils, they had elections. And the incoming council had a different policy. They were not wanting to remove those assets from the balance sheet. They thought that they would keep those houses and that they didn't want to sell them. So as a consequence of that council election, there was a change in control in the Manchester City Council, and the policy was discontinued. So that happened after he submitted his application, but before the documents were processed anyway. So Mr. Gibson, no doubt as a test case, chances are there are many others in his situation, argued, actually there's already a binding contract. You have agreed to sell me the house, so you need to follow through. So now, most of you will have read it, so you know how it turned out, maybe. What do we think about this? I'm not really looking for the result here. I'm asking you what you think about this situation. Do we think that Mr. Gibson had a reasonable claim? Do we think he should have had a better or a worse claim than he did? Whose side are you on? Or do you just find it very difficult to care about council house owners in the 1970s?
He probably had a reasonable claim.
He has a reasonable claim.
However, it probably is not kind of proved enough to say that he has actually made a proper offer.
So there's a couple. Let me unpick that. It's Sarisha. So the question is, was there an offer? And you said, your words were, maybe there's not enough to see whether he made a proper offer or not. Now, who thinks that he was making the offer for the house? See, this is why I like to do it anonymously, because everybody's like, he's making an offer. The words in the form were, God, I'm going to have to put this down because I keep moving things around and changing this recording. It's going to be terrible. The words in the form were application for a council house. I'm applying for it. So that, and we'll see a few more cases that look to this, that actually indicates an offer. Having said that, the terms on which the council might be prepared to sell the house were set out in that letter in some detail. They included terms on which they would lend him money and what the mortgage would look like. They included a price. He didn't change that price in any way. So again, it's messy, but I think there are strong arguments either way. So let's have a look at what the arguments were. Mr. Gibson said that the letter on the 10th of February was the council's offer to sell the property, and that by returning that application on the 5th of March, he accepted that offer. And again, standard is you have an offer, you match it with an acceptance, you communicate that acceptance, so putting the form in the post, they matched, that equals an agreement. We've got an agreement, you have to sell me the house on those terms. And so the issue before the court was whether the correspondence between the parties could be a legally enforceable contract. Now, an overlay, again, might not have come through in the extract. This is a contract relating to land, so, or an interest in land, so there is a formalities requirement. So it doesn't, if you don't have paper, it doesn't mean you won't have a contract, but if you don't have paper, interesting problem we were talking about in the break, if you don't have paper, it's very difficult to enforce a contract, particularly in relation to land, because there is a statute that says you can't, courts won't enforce contracts relating to land unless they're in writing. So we have that particular issue sitting there as well. So what was the writing? And we were looking at multiple documents. So the court said, look, actually, we're just going to take a conventional approach here. We're going to unpick the offer and acceptance. And so we're going to look at that different documents that the parties are relying on, or that Gibson was relying on as constituting the contract, and we're going to see upon their true construction whether there's an offer and an acceptance. Now, construction here doesn't mean that they're building a new house. Construction here is used in the term of understanding the contract. So construing a contract means understanding a contract. And you'll see the language about construction of contracts. It's really about understanding what the terms mean.
Is the fact whether like an appointed role or whoever signed off on that, is that relevant to, like, is that a second component of what? At some point an individual or representative agreed to that?
So, sorry, what's your name?
Chrissy.
Chrissy. Sorry, I'm trying to learn people's names. I don't know if you noticed that. Doing very well. So Chrissy's question is, I'll stand close enough so you can kick me if I get it wrong. So her question is, somebody quite senior signed off on that letter. Is it relevant that somebody who had treasurer in their title signed off? What do we think? And you are Stephen.
It has to be, because if a customer service officer who has no authority goes and makes the offer, they may not necessarily have the authority to make that offer or for it to be binding.
So when we get to privity, we'll talk about this in a little bit more detail. But I think what Stephen says here is correct, that if we go back to that American definition of what an offer is earlier on, if using an objective test on a reasonable person would assume that a document that's signed by somebody who is called director or CEO or treasurer has more meaning and is more likely to be a serious document than something that's signed off by head of janitorial services or adjunct lecturer, RMIT. No power whatsoever at all. I think they're exactly the kind of things that we need to look at.
I was looking at it because it said it was a policy of selling houses. So then do you have a delegate who I don't know, you would have some kind of delegation system, and are they representing the whole MCSD as a body, or I guess
Again, the kind of question you're going to, sorry, I'm just trying to make sure you end up on the recording, and so I'm wandering over here. But the kind of questions you're looking at are probably more outside into, they're almost corporate law questions. Right. So the questions about who has the authority to bind the company. Right. So right now I actually want to pair us back, about 2 steps before that is, if we assume, we can just assume that the parties were able to enter, had capacity to contract effectively. They're really good questions though, I really don't, and they go to the reasonableness of an assumption that it's an offer. They would be one of the pieces of evidence that go to that question of it's reasonable to assume that it's an offer because it's the council has this policy and a person who it's reasonable to assume is responsible for giving life to that policy is writing to me and setting out the terms on which they will or they may agree to buy the house or sell the house to me. But right now we just need to pair it back to, is it an offer? So we can assume that it's a person who has authority, but is it an offer? Let's just have a look at the wording. Sorry, this is all a bit messed up. But let's have a look. This is exactly the same slide as last time with a few words highlighted. So the corporation may be prepared to sell the house to you.
Doesn't say will.
Doesn't say, we will sell you the house, or we are offering to sell you the house for this price. It says, we may be prepared to sell. The maximum mortgage the corporation may grant. Now, may there could be read in two ways. It could be the maximum amount we're able to lend you under our rules is this, or the maximum amount that we might lend you if we decide we want to lend to you. We could read that in two ways, but I think the earlier words, may be prepared to sell, are probably more instructions. Then, actually, this last paragraph, if you would like to make a formal application to buy your house, please complete the enclosed application form and return it to me. In other words, make me an offer. So the act of applying, because again, we don't have a copy of the form, but my guess is that the form is going to actually include information like, have you got the financial ability to repay the loan? Are you going to finance it yourself, or are you going to borrow from us? So they've got some choices to make in relation to that. And we'll look at a number of cases. This is quite a usual way for large companies to form contracts as well. They get their customers to fill out application forms. So the customer makes the offer. Anyone who want to hazard a guess as to why you might structure things that way?
I'm guessing so they have the power to accept it.
That's a bloody good guess. What's your name? Sorry? Ken. So Ken is absolutely right. He or she who makes the offer is the one with the least power. He or she who writes the terms has the most power. But by making the offer, at the point at which the offer is made, all you need to do to create a contract is for it to be accepted. If you accept it with a variation, it's not accepted. That's a counter-offer. So, again, if I decide to lend Ken money, I much prefer to structure that in a way where he applies to me for a loan, so I'm in the position where I can say yes or no, rather than me just giving a blanket offer. I'll lend you 2,177 quid on these terms, do you want it or not? If you say yes, I'm bound, and I've got no idea about your capacity to pay. You look like you're good for it though, so that's why I was careful to choose you. So can you see how the words here are really quite important? So the court held that the words may be prepared to sell if you would like to make a formal application to buy made it impossible to construe, to understand this letter as a contractual offer. The letter and the application form simply set out the financial terms that they may be prepared to consider a sale. As a consequence, it was well within their rights to change their mind or to not accept an offer. An offer might have been made, but it wasn't accepted.
So would the tender process be seen as like similar?
Let's come to tenders before we get to the end, because we'll look at Havela if I get there in time. Clay.
Just to clarify, does that mean that letter was like an invitation to treat or
Yeah.
something else?
It was. It was exactly an invitation to treat. It was basically saying these are the terms on which we'd be prepared to negotiate with you or accept an offer. Chrissy, yes? No? Oh, God, I thought I'd lost it already.
So what about the sentence saying this is not an offer of a mortgage? What is that relevant?
Yeah.
But it's
not picked up yet?
Oh, I didn't. Well, because I was looking at this council house thing in particular. Sorry, I've just tried to keep it simple. But the word saying, this is, I'm not offering a mortgage, it's a weird kind of that we're not offering a mortgage. It's bad language because they're not in a position to offer a mortgage. It would in fact be, what they mean is, we're not offering you a loan. And it makes it kind of confusing. I'm sure the conveyancers amongst here would have been going, what are you talking about? Because the mortgage is actually given by the homeowner. But again, this is because it's non-lawyers writing these documents. Now, you know, if we were advising the council in the future, we might be saying, well, either, hey, you've got an election. Route one might have been, you've got an election coming up. If you want to sell these houses before the election, you need to make it really clear that applications need to be in by X date so that you can process them as quickly as possible. Might have been a piece of advice. I would call that the Victorian government approach to building roads. Another approach might have been advising the council is actually, yes, your forms need to be clearer. It needs to be very clear that this is not an offer. In order for you to buy your council house, you will need to provide us with this information, and we will then consider it, and we will need to accept your offer when the application is made in the proper place. And there's no guarantees that we will make it, that we will do that. So, was the decision fair? What do we think? Yes? Fair to Mr. Gibson?
Well, actually, yes. I think it's fair to him because I think the overall result was fair, so then it has to be fair by both parties. I think that the wording on it it wasn't ambiguous. It was, to me, it was fairly clear that this is what we may consider. Not we intend to be bound by this. If you just sign here, it's all done. I didn't read it that way. So I think for Mr. Gibson, it's harsh, but it's fair.
So if we want to make sure that that contractual arrangements with consumers generally, or let's call them civilians for want of a better word, generally, if we want to make sure they're fair, then we should just make sure that the words are really clear. I think it would help, but I think it's unrealistic. I mean, you know, I might be showing my politics in the view, but I think one of the things that the law does, we rely on disclosure and words all the time, yet we know people don't read them. So my background is as much as anything in fundraising. So, you know, for those of you who want to spend some part of the summer with me, we'll be doing some acquisitions, takeovers and mergers. And the way that the law deals with fundraising in particular and investments is, yes, we have to have a prospectus or a PDS and we have to tell people about the risks that they're taking. But we know people don't read them. We know even when they do read them, what are the chances that they understand them? You guys are by definition of above average intelligence, and I didn't ask in advance you know, how closely you read that letter, but it was assigned to you as something to read. You know in your heart of hearts how much sense that made to you. How much sense is it going to make to poor old Mr. Gibson in 1971, who's lived in a council house all his life? I mean, maybe I'm casting nasturtiums, as my father would say, but again, we've got to think about these things. So Lord Diplock in this case says, whether one thinks this makes it a hard case perhaps depends on the political views that one holds about council housing policy. But hard cases offer a strong temptation to let them have their proverbial consequences. It's a temptation that the judicial mind must be vigilant to resist. Effectively what Diplock is saying here is, yeah, I feel sorry for Mr. Gibson. He thought he was going to get his council house and he missed out. And I recognise that some people will have views about the politics of this one way or the other, but we need the law of contract to be consistent. So as tempting as it might be to find a loophole that looks after Mr. Gibson, actually there are bigger long-term benefits in applying the law in a really consistent way. There's nothing particularly crazy or interesting in the way the law's been applied in this case. It's just that the result is probably one that many might not think is the right result. So let's talk in the 25 odd minutes that we've got left about Carlill and Carbolic Smoke Ball. I actually had in the quiz earlier a little picture of a smoke ball. Here are some of the advertisements that were referred to in the case. So 1893, 30 odd years ago, getting there. At the time that this case was decided, the law of tort was pretty stagnant. And I think many of us looking at this case think, why would you bring these facts in a contract case? Surely this is a product liability case or a misleading and deceptive conduct case. This isn't a case about contract. But because of where the law of contract was at this stage, this is the law that the case or the action was brought in. And as a consequence, it has really become a seminal case because it illustrates so many points about contract law. So I know you've read it, but just in case, because it's difficult to read, I'm going to actually go through the facts on this one to make sure we're all on the same page with it. So material facts are as follows. The Carbolic Smoke Ball Company, or the defendants in this matter, printed some advertisements, you saw them on the slide before, to promote a product called the smoke ball. The smoke ball is a device that you could use in accordance with the instructions on the packet, that you would inhale it however many times a day. It was a preventative puffer, effectively, and it said, or they said, that if you use this in accordance with the instruction, you would not get the flu. Now look at the timing. The Spanish flu wiped out more people than Ebola, not all that long before. Flu was a serious illness, as it is. In fact, this has been one of the worst flu seasons ever this year, but it wiped out a huge number of people in Europe. For some reason, last time I had the number in front of me and I can't remember now. As part of this advertisement, they offered, inverted commas, offered to pay £100 to any person who got the flu after using this device in the way it was prescribed. The advertisement also said that they put £1,000 in the bank to show their sincerity in the matter. Poor Mrs. Carlill used the smoke ball in accordance with the instructions, but she got the flu. She then said, okay, I got the flu, I'd like my £100 please, and they said, bugger off. That's not what, we're not going to pay you that £100. That was just advertising. So, let's have a look at the advertisement. The words say, a £100 reward will be paid by the company to any person who contracts the increasing epidemic influenza, colds or any disease caused by taking cold after having used the ball 3 times a day for 2 weeks according to the printed directions supplied with each ball. £1,000 are deposited with the Alliance Bank Regent Street, shewing our sincerity in the matter. Couple of things to point out here. That deposit, I think, is really relevant. I think it's also worth thinking about what £100 is actually worth. So this is like, think about that advertisement for Soldier On, is it? Codral cold and flu tablet, Soldier On, you'll be fine. And if you're not, I'll give you a close to $23,000 as compensation for you getting the flu. Okay, it's a lot of money. That's what the spending power of that money is. So the issues in the case were whether or not there was an offer. Was there an indication by one person to another of their willingness to enter into a contract on certain terms without further negotiation? And was it an offer to contract, or was it merely an advertisement or a puff? Now, hence my reason for doing the currency conversion for you. By the way, it was more than 23,000 6 months ago. It seems that the dollar and pound are... Oh well. Anyway, so what do we think? Soldier on, I'll give you 23,000 bucks if you get the flu. Is it a puff or is it a promise?
I think it's a promise. It's like finding, please find my dog, I'll give you $100.
Please find my dog, I'll give you $100, or I'll give you $23,000. Rocky, are you feeling unloved? Well, court agreed with you, but let's have a look at the argument. So the defendants here, Carbolic Smoke Ball, argued the following. They said, no, we didn't make an offer. That's ridiculous. Then the words do not express a promise, and we didn't intend to make a promise. We never had any intention of paying out.
When they deposited the money in the bank.
Well, they said they deposited the money in the bank. To be quite frank, I don't know whether they did or not, but they said on the advertisement that they put it in the bank, but they had no intention. Just like I say, I'm going to finish on time and get through all of these things, and I might have no intention of doing it. Again, I mentioned before that this case is good authority for the use of the objective test. Why is it authority? Because this is what the judges held, but this is what the defendants argued. So ultimately the judges held something in response to these statements. They also said that the advertisement was a puff or a boast, and it wasn't meant to be legally binding. It was basically saying, this product is awesome. Like that Lynx deodorant, you know, like I'm sure my son genuinely believed that many, many girls would come flocking to his bedroom because the whole upstairs in our house smelt of cheap perfume from the age of 14 to the age of 16, I'm sure. Actually, some days now I want that back. It's disgusting again. Anyway, I really shouldn't say things like that on the recording. Stop. Next argument. Mrs. Carlill, even if, so we've talked about this before, often when you're arguing things as a lawyer, it's like, well, there's no contract at all, or there was no promise intended. But even if we made an offer, even if, my learned friends, you find that there is an offer in this case, well, Mrs. Carlill didn't communicate her acceptance of that offer. And we know we need offer matched with an acceptance, and the acceptance needs to be communicated. No consideration moved from Mrs. Carlill in exchange for the promise to pay $100, 100 quid.
What do you mean by no consideration?
So we'll talk more about consideration. Think about consideration as price. There was no exchange or no swap. So we'll talk about this case. We'll talk about this case in every element to an extent. But consideration. So she didn't pay for that. She paid for the smoke ball, but she didn't pay. They're arguing for the promise to pay 100 quid. Again, we look at it this oddly too because we're thinking we are informed about our rights as consumers based on what we understand to be correct and appropriate now. But back then they're saying, well, in order to have a contract, for any promise to be binding, it needs to be made in exchange for consideration. There needs to be a price paid for it. And it goes actually, I think it was Craig who earlier said, in relation to the lost dog, there are two obligations. Is it two contracts? They're effectively trying to make that kind of argument. Two contracts. I need a price paid for the smoke ball and some kind of price paid for the promise to compensate me if the smoke ball doesn't work. And ultimately, what the court held here is, no, actually, she bought the smoke ball. The consideration she paid was for the combination, the promise that the physical smoke ball and the promise it would work, that was backed up with a guarantee that if it didn't work, she would get some compensation. Then they also said that the advertisement itself was too vague or too uncertain. So, for example, it didn't have a time limit attached to it. Sorry, somebody was about to ask me a question before.
Consideration have to be monetary.
No, consideration doesn't need to be monetary. I'm just going to...
with her health. You know what I mean?
Yeah, she paid with her health and her reputation from now on forever. Mrs. Carlill will be remembered through all time. But yeah, consideration, we'll spend a lot of time on consideration, but I just want you to think about it as price for now, but it's much more complex than that. It's an exchange of things. It could be promises, it could be anything. So that was what the defendants argued. We've talked about some of the responses to those arguments as we've gone. The plaintiff on the whole said, well, actually the advertisement was an offer to all of the public, to anybody who could read a newspaper. As soon as Mrs. Carlill did what the advertisement directed, she had a contract with Carbolic. Again, it's a unilateral contract. It could be accepted, and the contract was created by doing the thing. So, well, actually, I'll get to what the court said in relation to the communication of that acceptance, but the contract was made when she did the thing. The thing that she had to do was use the smoke ball in accordance with the directions. So if she just bought the smoke ball and put it in her medicine cabinet, which is the way I tend to deal with these kind of things, she wouldn't have been able to claim, I got the flu, I bought it, but I got the flu. Did you use it? No, I didn't. No contract. But she was able to demonstrate somehow that she in fact used it. So when she fell ill with the flu, she was entitled to claim the 100 quid under the contract. So what did the judges say? You can make an offer to the entire world, and that offer will ripen into a contract when someone comes forward and performs the condition. It's a unilateral offer and a unilateral contract. So the unilateral contract is made at the point when the acceptor, the offeree, does the thing that the offeror requests that they do. So at the point in time when the contract is made, only one party has an obligation, and that is the offeror. Acceptance of a unilateral offer occurs by performing the condition, and notification of the acceptance can occur at the same time or a little bit after performance. So the acceptance doesn't have to follow identically. Ultimately, what that means is that if a unilateral offer is withdrawn before that acceptance is communicated, then we don't have a contract, because the offer needs to be live during the period of time when it's accepted. So once it's withdrawn, the offer lapses and it can't continue on. Now, again, I think if she'd been running up the steps with her application form for 100 quid and they sort of held the doors and then quickly started typing an ad in the paper saying we withdraw our offer, they might have had some problem. But at the time she brought the request for 100 quid, they hadn't done anything about withdrawing the offer, so that particular point wasn't tested. So that brings us to this idea of unilateral contracts and bilateral contracts. I am really sorry, we are going to be running a little bit behind because of those technical issues that we had at the beginning. So let's just make sure we understand unilateral contracts and bilateral contracts quickly so that we can talk about them. So, features of a unilateral contract. We've got two parties to a contract. Let's call them A and B. Jack and Jill. I don't know, just A and B seems so boring. Only one promise is made. For example, A promises to pay $100 to B if B finds A's lost puppy. B accepts the offer when they perform the stipulated task. The contract is formed at the time that B performs their obligations under it. And that's why it's called unilateral. So it's not unilateral because there's one party. It's unilateral because there is only one party who has an obligation at the time that the contract is made. I'm trying to think of there's an Australian case, McRobinson, which I know a number of you have been struggling with, and I don't think I'm going to get to this week in the end, not until a Tuesday anyway. But in McRobinson, I think Justice Barwick is the one who talks about unilateral contracts in that case. It could be one of the other two though, I'm remembering it as Barwick. And he talks about how it's a misnomer, that calling a unilateral contract unilateral is a misnomer because it's not a one-party contract, it's just a single obligation contract or single set. So this is my quick and dirty way of drawing this up. I hope this makes it helpful as opposed to more confusing. So if we have a unilateral contract, we've got a person, an offeror, We always know the offeror because they're blue. Offerors are always blue. No, they're not. The offeror makes an offer. They have no obligation until the conditions attached to acceptance are met. They can withdraw the offer at any time. So all they've done is made an offer. They're not obliged to do anything. They have just made an offer. An offer that they might, an offeree, a person who comes across this offer has no obligations to do anything. Offerees are always pink. But if they do what the offeror asks, then a contract is made. Couple of little stipulations here. For example, the offeree could be anyone, unless, of course, the offeror stipulates that it's only a particular person or a particular group of people that they fit within a class. The other thing that's worth noting here is that they need to do, the contract is made if they do the thing, provided that they do it before the offer has been withdrawn. So, Emily frantically searching for her lost puppy, and then suddenly she realises, I don't have any dog food anyway, and that really would stop my problem with the neighbour who's complaining about it barking. Actually, I might just go down and rip off those signs and just see what happens. I don't have $100. Whatever it happens to be, the offer's withdrawn, then Clay frantically searching for the puppy. Too bad, so sad if she gets back late after the offer has been withdrawn. Once a unilateral contract is made, the offeror is bound and the offeree has rights. But the offeree isn't bound anymore. Like, they've done everything that they needed to do. And there are no particular rights. There's no exchange necessarily coming back. The consideration is paid. Chrissy, did you have a question?
I did. If someone returns the dog, so before you said someone brings the dog back and she says, I'm not going to pay you.
Yep.
How is that different than her taking down a sign and deciding she's not offering anymore, and then the person...
Well, let's
isn't
work it through.
aware?
So we're going to use an objective test.
Yeah.
Okay, so I think if we're using an objective test as to whether an offer has been made or not. So if, Emily, if I can use you again as a person who has lost her dog, put out a reward. If she's, in her mind, she thought, yeah, no, I don't really want my dog back anymore. That would be me. I don't really want my dog back anymore. That's what we're going to do. But she didn't tell anybody. Would the objective test be made? No. It's because what's inside her head doesn't matter. She would have to act.
If she went and took the signs
But
down,
if she's taken the sign down, if she has, if the Smoke Ball company, they made their offer by putting a notice in a newspaper, if they put a notice in a newspaper saying offer's done, we're not going to do that anymore, it's reasonable, using an objective test, they've used similar steps to the steps that they made the offer to undo it. Now, if Emily had just said to Clay, oh, if you see the dog, I'll give you $100 if you bring it back to me, then I think Emily would need to contact Clay and say, oh, you know how I offered you the $100, that's over, you know, I'm not doing that anymore. She would have had to have, you need to, again, an objective test, and a good basis for the objective test is, how did you make the offer? Then communicate your withdrawal in a similar way. Okay? All those, you're all going to be ripping off those phone numbers on signs now. And bilateral contracts, on the other hand, at the time the contract is made, that amorphous mess of pink and blue in the middle there, so an offeror, remember they're always blue, has made an offer. The contract is made at the point in time where the offeree, in pink, accepts. So our contract is made at this time of that meeting, the meeting of the acceptance with the offer. And at the time the contract's made, it might only be for milliseconds afterwards, but at the time the contract's made, both parties have obligations. Okay? Our offeror has obligations which ultimately turn out to be rights for the offeree. And the offeree, and this is ultimately what consideration is, will have some obligations which turn out to be rights for the offeror. So think about this as simple as buying a cup of coffee. I make an offer to buy a cup of coffee, turn up, point to what I want, or say, you know, I'll have a large skinny latte. I see a menu, it says it's $4.50 or something equally outrageous. I hand over my keep cup. We might not have much more than a conversation than that, but I have made an offer to purchase coffee. I have an obligation at that point in time to hand over $4.50 at some point in time in the future, probably only minutes away, possibly immediately, and then I sit and minutes later, my keep cup will be returned to me with a skinny latte inside. If I'm really lucky, a nip of brandy. But contract is made though well before. Sorry, there's lots of action. Okay, I'm going to stop us there rather than get us into a new case. Before I give you sort of action plan, questions, concerns, frustrations, compliments. Okay, an apology. I had no expectation of that level of drama today, yeah, it's difficult for everybody when I can't actually use the slides and record, so I apologise for that. We will have a toot 6:30 on Sunday night. I will actually be in Mount Buller. Does not suck to be me. I think that what I will do is I will do the toot before I do the drive home. So that is my plan. There are quizzes for this week. The very first of your discussion board problems is available for Sunday. For face-to-face students, there are no marks associated with that, but there are, you get feedback. How good is that? If you have questions, feel free to share them. I will provide a link. I've come up with a little plan. Don't know if it's going to work, but for you to just using that survey, or you know, like that thing that we were using, the Nolan poll everywhere at Nolan Legal. There will be a link that's available to you all from tomorrow where if you have a particular question or issue you would like to see discussed at the toot, you can put it in there, or you can vote other people's issues up or down as well. So I just thought that might help. Thank you to those of you who came to the toot last night. Have a good week. Can only get better from here, right? Okay, thanks guys, well done.